Please, your lordships, in this matter, I appear for Bellini with Mr. Neil Fawcett, Mr. Keeley and Mr. Wright appear for Brit Insurance. This is an appeal against the judgment of Deputy Judge Clare Ambrose, the 26th of June 2023, and as my lords will have probably seen, Bellini is an Italian restaurant in Sunderland. It made a claim for an indemnity on its insurers because it was closed down by government regulations because of the COVID-19 pandemic. Bellini has cover for inter alia the occurrence or the for infectious diseases within 25 miles of the premises, and its cases, those cases which occurred within 25 miles of the premises were concurrent causes of the restrictions which caused its business interruption loss on the basis of the causation analysis of the Supreme Court in the FCA test case. The learned, and this case depends upon primarily the construction of clause 8.2.6 of the policy. The judge held that on the proper construction of clause 8.2.6 of the policy, there can be no cover in the absence of damage, and such damage is physical loss, physical damage, and physical destruction. Now, Bellini submits that the deputy judge fell into grave error. She adopted a literal, legalistic, and pedantic interpretation of clause 826, regardless of the absurdity of the conclusion to which such an approach would lead, and the fact that would denude the cover under clause 8.2.6 of any sensible application. And we say, my lord, that if there was no cover under clause 8.2.6 of the policy, unless physical damage was caused by the perils set out in that clause, then that cover would be wholly illusory. Or
that cover would be wholly what?
Sorry, my lord?
That cover would be wholly
illusory.
So let's assume you're right about that. Does that entitle us to rewrite the contract so it's not illusory? How do we decide what cover there should be?
No, we do not say that you should rewrite the contract. What you can do is you construe the contract, and if it becomes clear that there is a manifest error in the drafting of the contract, you can correct that by way of construction.
Can you tell us how we are to correct the manifest error by a process of interpretation? I prefer interpretation to construction.
Oh, so be it. Well, my lord, if I can go immediately to clause 8.2.6.
Yeah, where are you looking at it?
I'm looking at the supplemental bundle at page 29.
Perfect.
So that says we shall indemnify you in respect of interruption or interference with the business caused by damage as defined in clause 8.1. Now, it does not say, my lord, there, caused by damage, defined term. It also does not say caused by damage as defined in clause 18, which is the clause 1816 on page 70, which is the definition of damage, which says physical loss or damage. So it says as defined in clause 8.1. Well, if one looks at clause 8.1, my lord, there is no definition of damage as such in clause 8.1, because what clause 8.1 does, it sets out business interruption coverage. Clause 8.11 says if there is damage to property used by you at the premises during the period of insurance, In consequence, the business carried on by you at the premises is interrupted or interfered with, then we will pay in respect of each item of business interruption insurance stated in the schedule the amount of loss resulting from such interruption or interference, provided that at the time the damage occurs, they enforce either cover under the section's building or contents, an insurance policy covering the interest of you in the property, or B, at the time the damage occurs, you've claimed under the policy referred to now, the relevant insurer has paid. A liability under this section shall not exceed the sum insured at any applicable sub-limit. So that sets out a basic business interruption coverage where there is damage to property, but it doesn't define damage. And then what the rest of the clause does is sets out gross profit, estimated profit. If the cover is based on the loss of gross profit, that's how you calculate it. And in 8.14, if the cover is based on gross revenue or estimated gross revenue, it tells you how you calculate it. So, but there is not a definition of damage in clause 8.1. So when one looks at that, with all due respect, 8.26 begins with a nonsense, because it doesn't say we will indemnify in respect of damage, and it doesn't say we will indemnify you in respect of damage as defined in clause 1870, I think is the relevant clause. What it does is it says we will indemnify you in respect of damage as defined in clause 8.1.
So you might then understand that as meaning damage is defined in 18.16.1. Might you?
No. In my respectful submission, not, because it says 8.2.1. What it intends to do, what's intending to do in 8.2.6 is to refer to 8.2.1 or to 8.1 in order to set out the way of calculating the loss. If, for example, gross revenue, as this policy is, you look at 8.14 to work out how you calculate the gross revenue. And this, in my respectful submission, is clearly the case when one looks at the other covers under 8.2, because what one has here is 8.2.5 at page 29, denial of access. We shall indemnify in respect of interruption or interference with the business caused by damage as defined in clause 8.1 to property in the vicinity of the premises, which shall prevent the use of the premises or access thereto, whether the premises or your property therein shall be damaged or not, excluding damage to property of any supply undertaking. Now, that cannot be, with all due respect, a reference to 8.1.1, because 8.1.1 sets out the position where, or a requirement, where the assured has a policy covering property. And of course, the insured will never have a policy covering the property of somebody else, which is what 8.2.5 is dealing. If one ignores 8.2.6, which I'm going to come to, and goes to 8.2.8, suppliers, we shall indemnify you in respect of interruption of or interference with the business caused by damage as defined in clause 8.1 at any premises of any of your direct suppliers within the United Kingdom. Now, what that means is that if Bellini's business is interrupted because their pizza supplier 100 miles away has some fire or flood, then there would be cover. But of course, as defined in clause 8.1, cannot under that cover be referring to 8.1.1, because Bellini would never have an insurance policy which covers the premises of one of its suppliers. It would never have an insurable interest in that. And
I mean, I do get the point, but can you say how you would replace the words damage as defined in clause 8.1 so as to reflect what you say it was intended to mean?
What I would say, my lord, is I would omit those words. Those words make no sense in respect of these covers, or alternatively, in a very ham-fisted way, it's intended to refer to, in this policy, 8.14. Because
you would omit the words damage as defined in clause 8.1 wherever they appear.
Yes. Or
how many times do they appear in
they
clause
appear,
8.2?
I do not say, my lord, that one omits the word damage in other respects. I would omit it in relation to 8.2.6 or 8.2.5 if one's dealing with denial of access, or 8.2.8 in suppliers, omit it. Or alternatively, one could construe it as referring to the way that 8.1 sets out the, depending on whether it's gross profit or gross revenue, the way you calculate it. But if one looks at 8.2.6, once you realize that this is intended to be a non-damage cover, when one then sees, for example, at the bottom of 8.2.6, the insurance by this clause shall only apply to the period beginning with the occurrence of a loss and ending not later than 3 months thereafter, during which the results of the businesses shall be affected in consequence of the damage. Damage in that section refers to the insured peril, because once you realize that this is a non-damage cover, you construe damage as insured peril, as indeed has been the case in other examples of damage in the trends clause or in the savings clauses, in the FCA test case, in the Irish case of Hyper, in Gatwick Investment and Liberty Mutual. So once, what one finds in this area, as I'll explain, my lords, that the non-damage extensions are based upon a framework where the basic cover is for business interruption caused by physical loss and damage. And
where are the insured perils defined? I mean, I'm just trying to be absolutely clear as to how you say this contract should be read. So you say it should be read as the insured perils. What are they?
So, for example, the insured perils, for example, in 8.2.6, the insured perils are those set out in A to E.
So in consequence of the assured perils set out above at A to E.
Yep.
Okay. And what do you say the words caused by damage in the first 2 lines of 8.2.6 should be read as meaning, or should they be just simply removed?
I would submit they should simply be removed, because there is not a definition of damage in clause 8.1. 8.1 sets out the basic cover and also sets out the machinery of assessing loss. In my submission, that is the reference to as defined in clause 8.1 is an attempt, but a confusing attempt, to point the reader to the relevant way of assessing the loss. So if the policy is based upon gross revenue, then you are pointed to 8.14, that this policy is based upon
What did the judge say about the argument that the real vice in this clause was the word as defined in clause 8.1 rather than the definition of damage?
What?
Was that advanced before her at all?
I was not there before the first instance charge. I think it was advanced before her, but it doesn't refer. You see, we do have a definition of damage in clause 18.
We do.
We do.
And we have a bold term, a bold phrase, and we have a clause that explains what bold phrases mean.
One sees that except one sees at page 70.
70 of what?
70 of this damage means physical loss, physical damage, physical destruction. That's 1860. But this particular clause 8.6, as indeed some of the other extensions in 8.2, do not just say damage. They say damage as defined in clause 8.1.
No,
and therefore,
I see that. But what I asked was, did the judge deal with that point? Did the judge say why she thought it said damage as defined in clause 8.1 as opposed to damage as defined in clause 18.1.1?
I don't think she did deal with that point.
No.
I don't think she did deal with that.
I think your junior is trying to give you a bit of help. Yeah.
I'm pointed to page 68.
In the policy.
Page 68 in the core bundle relating to the judgment.
Which paragraph?
Paragraph 14. Where the judge said the claimant submitted it was significant that clause 8.2.6 did not refer to the definition of damage in clause 18.6.1, but instead referred to damage as defined by clause 8.1 in circumstances where clause 8.1 did not define damage as physical damage. Clause 8.1 was not concerned with defining the word damage, but was more widely providing machinery for standard type business interruption cover, including the method of calculating and so on. The extensions were thereby restating the machinery of standard cover and extending it to things not already covered. And then she then said the claimant argued that if clause 8.6.1 also respond to physical damage, then this would render cover illusory. So she did refer to the argument.
But the argument was they're instead referring back to damage in its entirety in the context of clause 8.1. So that was what Mr. Fawcett had put to her. Then where does she say that was wrong?
I'm not sure she does. She basically had the argument or put forward the reasoning that damage
then she
means
says it's
damage.
a very simple case, damage means damage.
Damage means damage.
Yes.
Exactly.
The learned judge dealt with it in her brief way, paragraphs 24 and 26.
24 and 26.
Which are to be found at page 71 of your lordship's court bundle.
Yeah. Mm. Yeah. Thank you. So she just really says, doesn't alter the meaning of damage.
No.
And also in 24, she says that the reference back is to the type of business interruption
Yes.
in question, which was an argument advanced by Mr. Wright behind me.
So the draftsman, whoever he or she was, refers to damage as defined in clause 8.1. But there isn't a definition of damage, and clause 8.1 either points you to the basic cover, where the basic cover is if physical damage causes business interruption loss. And then the rest of clause 8.1 sets out different methods of calculating loss depending on which is the applicable basis of cover in the schedule. And in the schedule in this case, the right basis is gross revenue. And as I've said, if you are looking at, if you are pointing to 8.1, and if you say, well, you've got to look at 8.1.1, which requires there to be a policy which covers damage to the insured's property effectively, and the insured has made a claim on it, then that makes, in my respectful submission, a total nonsense, not only of 8.2.6, which is the one we are really dealing with, but a nonsense of 8.2.5, which effectively relates to denial of excess because of damage to someone else's property in the vicinity of the premises, because it says whether the premises or your property shall be damaged or not, so there's cover there. If damage to the premise, if there is no damage to the insured's premises, we then look at suppliers, which I've shown, my lord, which provides an indemnity if there's an interference with the business of any of your direct suppliers. They could be 150 miles away.
So Mr. Gruder, I mean, I completely get the point.
You can get the point.
I completely get the point that it's a clause which doesn't extend the cover a lot or at all if you read it as it is written. But my question is, how do you know to make the amendments that you have invited us to make? You've given us 3 clear amendments to make to the clause, which would achieve what you want. But how do you know to make those amendments rather than some other amendments, which, for example, caused by damage as defined in 18 point, whatever it is, 1.6 or 6.1, or not taking out caused by damage, but saying caused by insured perils?
Because...
How do you know that?
I take that point head on because my amendments make sense of this policy. Whereas...
But is it the only way to make sense of the policy?
My lord, I didn't get...
Is it the only way
to
make sense of the policy? So you say my amendments are the only way to make sense of the policy?
Because if I take my lord's suggested amendment, which is to define, to replace as defined in clause 8.1 and substitute for it as defined in clause 18.17, I think, which is the definition of damage, there would be 2. First of all, it makes a nonsense of the policy. And secondly, there wouldn't be any reason for the draftsman to put in as defined in clause dot, 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 whatever the clause is. Because if he was really referring to the definition of damage in clause 18, he wouldn't need to put as defined at all. Because damage, he could have just left damage in bold. And therefore you would have looked at the definition of damage. So in my respect for submission, my amendment is the only one which makes sense of this policy. Because if one looks at murder, suicide and disease, which we are focusing on here, 8.2.6 at page 29, we shall indemnify in respect to interruption, interference of the business caused by damage, as defined in clause 8, arising from any human contagious disease, an outbreak of which the authorities stipulated shall be notified them, manifest by any person whilst at the premise or within a 25-mile radius of it. Now, if somebody has COVID-19 24 and a half miles from this restaurant in Sunderland, it's impossible for that to cause any physical damage to the premises. Now, it might be said, of course, and I think this is an argument put before the judge, that somebody might have an infectious disease on the premises and might fall ill and might be sick on the premise, and that might cause some damage to a carpet or some decoration. I mean, that is such a far-fetched example, with all due respect.
Or bloodstains.
Or bloodstain. Well, we'll come to that. That's such a far-fetched example that no rational... Of course, there would be cover there if there was a business interruption law, but this is such a far-fetched example that no sensible underwriter or assured would seek cover.
Are you going to address us on the law? My understanding of the law, I recently wrote a judgment in a case called Brit, where we talked about obvious mistakes, and I thought we in this court were bound by Capito and Wood and Rainy Sky. And they say if the words are clear and are not ambiguous, you apply them. And the authorities which I considered in Britvic concerning when you rectify, I say I don't mean rectify, when you change or interpret an obvious mistake, are confined, according to the authorities, to cases like Friday the 3rd of April, when Friday was the 4th of April, and it was obvious from the factual matrix and the rest of the contract that what they were talking about was Friday the 4th of April. So you do interpret the contract as meaning Friday the 4th of April so as to correct an obvious mistake. And that's because there's only one way to correct it, and that's what you do. Now, there's loads of cases going back to Lord Ellenborough to that effect. This is not such a case, is it? And, I mean, I don't want to make this all about me, but I wrote an article once about ICS, which is a case, as you may know, Mr. Gruder, since you and I spent 3 months together in it, after the decision of the House of Lords, is a case which probably would give you a better chance in this case, or might anyway, but we now look at Rainy Sky and Capito and Wood, and that makes it much more difficult for you.
Except, my lord, that there, I would say that the reference, and of course I do hear what my lord said, but the reference as indefined in clause 8.1 is itself a nonsense.
The reference is...
The reference in the clause...
As defined in clause 8.1
clause 8.1
is nonsense.
Is a nonsense.
I mean, that's a new point, isn't it, really, as being the key point in the case.
Well,
but now you say that is the key point, really.
It is a key point, well,
yeah.
Yes.
Because it makes... You say the clause just cannot be made sense of as it stands.
Yes, it can. it cannot be made sense of in that I would deny it's a new point, my lord. But what I also say, my lord, is one has to take on board the fact that one asks oneself, how are you meant to construe such policies? And the Supreme Court tells us that the way to construe these policies, and one finds this in paragraph 77 of the Supreme Court judgment, page 280 of the authorities bundle.
Yeah.
And what they say, what they say is, if I can get the page reference there, is paragraph 77. The court below saw no merit in, nor do we. The assumption the parties intended each of two seemingly inconsistent clauses in agreement have effect as a sound starting point, where the parties in the contract would reasonably be expected to have had both clauses simultaneously in mind. The cases cited by RSA were all cases of this kind. But sometimes that's not a reasonable assumption. For example, in the case of complex contractual documents, which themselves contemplate and provide for the possibility of inconsistency. In any event, the overriding question is how the words of the contract will be understood by a reasonable person. In the case of an insurance policy of the present kind, sold principally to SMEs, the person to whom the document should be taken to be addressed is not a pedantic lawyer who will subject the entire policy wording to a minute textual analysis. He is an ordinary policy holder who, on entering into the contract, is taken to have read through the policy conscientiously in order to understand what cover they were getting. So, in my respectful submission, one has to construe this not as a pedantic lawyer.
No, okay. I mean, look, I completely get all that, but I don't know what it tells us to do. I mean, I completely get that we mustn't be pedantic lawyers and that we must read it sensibly, but this is not reading it sensibly. This is ignoring words. I mean, you are telling us in two places to delete the words damage as defined in 8.1. Now,
in one place.
Even at, I think it's two places, you said we delete it in the second line of clause 8.2.6 and we delete it in 8.2.5 and 8.2.8.
Oh yes, when one looks at those different clauses, yes.
Yes. And we rewrite 8.2.6, the words in consequence of the damage, to mean in consequence of the insured perils set out at A to E above. Yes. And also you said the word, yeah, that's right. So those are the things. Now, how does even a non-pedantic lawyer do that? I mean, what are the tools that this non-pedantic SME person looking at it uses to decide those words mean nothing?
The tools are, well, first of all, the Supreme Court or the Divisional Court itself in the FCA in the FCA test case, when it was dealing with non-damage covers like infectious disease covers, and when it had a trends clause which referred to damage.
But that's because it was inconsistent with another part of the policy.
Well, it was inconsistent with the fact that the policy covered perils which did not depend upon physical damage. So what it was an infectious disease cover. I can show my lord what the Divisional Court said.
I read it this morning.
Pardon?
I read it this morning.
And what they said, my lord, was that in fact the FCA argued that the trends clause only applied if there was physical damage. The insurer said no, because one is dealing with a situation where the cover does not depend upon physical damage. It depends upon an infectious disease causing non-physical damage, causing loss. One has to read damage as meaning insured peril. So they effectively read damage as insured peril. So that, and Melanie Friend is wrong where he says it was conceded at all times. It wasn't conceded in the divisional court, because I should show my lord that.
Okay. Where is it?
One finds that in the divisional court, I think it's paragraph 117 in the divisional court judgment.
Page 155.
Thank you, Lou. Yeah, 119. So my lord has got that. He contends the trends clause, include of definition. This is notwithstanding trends clause is couched in terms certainly affecting the business, either before or after the incident. Incident is defined as loss, destructive, or damage to physical property. RSA contends that they should in effect be manipulated so that it's applicable to non-damage perils insured under the extensions in section 2. The FCA contends by contrast the indemnity under extension 7 is not subject to the contractual quantification machinery, and the trends clause is relevant only if that machinery is applicable. So the FCA said, because there was no damage to property, the trends clause was not applicable. The divisional court say, in our view, the policy is not well drafted. It should be construed as meaning that the contractual quantification provisions are applicable for the purposes of calculation indemnity under extension. It would, in our view, be commercially surprising if the parties intended that provisions related to quantification of business interruption claims arising out of damage should not apply with appropriate adjustment to claims in respect of non-damage perils, and so on. So, my lord, my submission is once one realises that clause 8, the reference to clause 8.2.1 is a nonsense, and this the actual cover does not depend upon physical loss and damage. The other references to damage in the indemnity period, or the other references to damage at the bottom of 8.2.6, the insurance clause will only apply for the period beginning with occurrence of the loss and ending not later than 3 months thereafter, in which the results of the business shall be affected in consequence of the damage. On the same basis of the same reasoning as in the FCA test case and some of these other cases we refer to the skeleton argument, damage there would be referred to as, would be construed as insured peril, because one is dealing here with a non-damage cover.
Doesn't that beg the question, Mr. Brewer? You say once you realise that 8.2.6 is a non-damage cover, then everything else follows. But
yeah.
The question is whether it is a non-damage cover, even though it says damage.
Well, it's begging that I do take my lord's point, but one does have one, the fact that it refers to damage as defined in clause 8.1, and one does have cover there which in certain respects is incapable of causing physical damage, and in other respects, if it could cause physical damage, could only do so in the most extraordinary circumstances that no rational parties would really consider that cover is intending to be provided against that. For example, let's look at E, my lord. The closing we should indemnify in respect of interruption, interference of business caused by damage as arising from the closure of the whole or part of the premises by order of a competent public authority, consequent upon defect in the drains or other sanitary arrangements at the premises. Now, the closing of the whole of the part of the premises by a competent public authority is never going to cause physical damage. It's going to cause economic loss. And consequence upon a defect in the drains, let's say, doesn't say consequence upon damage, a defect in the drains or sanitary arrangements, a defect is not physical damage. So one has got a sub-paragraph of that cover that we say is incapable of causing physical damage. The same goes for a human infectious or contagious disease within 25 miles of the premises. The same goes, in my respect for submission, human infectious disease at the premises. And the idea that somebody who catches or has an infectious disease at the premises might cause physical loss of the premises because he might be sick, we say is so far-fetched as to be ridiculous. Now, I said, my lord, in the skeleton, that there's a unity here which relates to authorities closing the premises. I think that probably went a bit too far, because there's a second unity to many of these, which is business interruption might be caused by stigma. So, for example, if somebody has had an infectious disease at the premises, people may say, if it becomes known in the area, somebody has had smallpox or some terrible disease at the premises, we don't want to go there. It may lead, of course, to the local authority closing it down, but it may, of course, lead to people not visiting the premises because of stigma. Let's look at murder or suicide in the premises. That is not going to cause damage to the premises. The idea that it provides cover if there is a stabbing and there is therefore blood stains to carpet or decoration in the premises is far-fetched. Why should there be cover if that's the case, but if somebody is strangled and there is no damage to the premises? It's just so irrational that is intended to be the cover. But murder or suicide in the premises may lead to the premises being closed down by the authorities to investigate the circumstances. Or it may lead to business interruption caused by stigma, because people may say, well, there was a murder in those premises, there was suicide in those premises, I don't want to go there, I don't want to take my business there. That's really what it's getting at. One then has injury or illness sustained by any person arising from or traceable to foreign or injurious matter in food or drink provided in the premises. Again, the food has to be provided in the premises, but the injury or illness doesn't have to occur in the premises. So there may be takeaway pizzas or pastas that in some way have some kind of food poisoning and causes people to be ill. Now, it of course would provide cover if people are ill at the premises. But in my respect for submission, again, it's wholly ridiculous to say it only provides cover if one of those people who are ill on the premises and cause physical damage to the premises because they are sick on the premises.
I mean, Mr. Gruder, speaking only for myself, you're really pushing at an open door when you say that the cover is negligible, if not non-existent. provided by this clause, and that it would not be what you would be expecting if you were an SME buying business interruption cover. My problem is only whether the law allows us to rewrite the contract where there are many possible ways in which one might do that. And that's my problem. So, you know, we've got limited time, and you do need to try and persuade us, I think, that the law, as it currently stands, and in a higher court than this, allows us just to rewrite it, because it's not the kind of thing you'd expect to buy. But the words are clear, and or clearish, and you say they're not clear, and that enables you to rewrite it. But if you assumed against yourself that the words were clear enough and the 8.1 point wasn't a winner, tell me how we can just ignore words in a contract.
Because, my lord, the contract is effectively obvious nonsense. If you construe the contract the way that the insurers want to construe the contract,
it's obviously bad value. It's obviously not a non-damage cover, which is what you might, if you didn't read it, think it was. But is it nonsense? And does it matter if it's nonsense? I mean, if it's clear what it means.
But my respectful submission is not clear what it means. And the idea that you grant cover for an infectious disease occurring 25 miles away from the premises, and you then say you only have cover if it causes damage to the premises, is, in my respectful submission, an obvious nonsense. And especially when it says damage as defined in clause 8.1, and there is no such definition. And of course, if one wants to look at the authorities, which I'm happy to do so, my lord, one, for example, obviously goes to Chartbrook, which is at page 36 of the authorities bundle, the relevant paragraph. And it's paragraph 22, which Lord Hoffman says, in East versus Poundhouse Plant Hire, Lord Justice Brightman stated the conditions for what he called correction of mistakes by construction. Two conditions must be satisfied. First, there must be a clear mistake on the face of the instrument. Secondly, it must be clear what correction ought to be made in order to cure the mistake. If those conditions are satisfied, the correction is made as a matter of construction. Subject to two qualifications, both of which are explained by Calmworth in his admirable judgment in KPMG, I would accept this statement, which is, in my opinion, no more an expression of common sense view. Do not readily accept that people have made mistakes or formal documents. First qualification is that correction of mistakes by construction is not a separate branch of the law. And then he refers to Lord Justice Calmworth. And then he says in paragraph 25, what is clear from these cases, there is not, so to speak, a limit, the amount of red ink or verbal rearrangement or correction which the court is allowed. All that is required is that it should be clear that something has gone wrong with the language. It should be clear what a reasonable person would have understood the parties to have meant. In my opinion, both of these requirements are satisfied. Now, in my respect, clearly something has gone wrong with the language, because the reference to as defined in clause 8.1 doesn't make any sense and can only possibly be read as a reference, as I've said, to the gross revenue. And then
Well, if that's the mistake, isn't the mistake that the parties have referred to the wrong clause, because the definition is not in 8.1, it's in 18.6 or something like that.
No.
And therefore they were probably intending to refer to the place where you do find the definition and not the place where you don't.
No, because I would respectfully beg to differ, because what they are intending to do by referring to 8.2.1 is to refer in those circumstances to the business interruption cover, and indeed the reference to, for example, gross revenue in 8.1.4, which is the relevant basis of cover in this case. Effectively, it's a rather incompetent way, we say, of seeking to point to the right way of calculating loss. And the fact that it would be wrong in my submission, and it wouldn't make any sense in terms of the cover in 8.2.6 to say that the reference as defined in clause 8.2.1 is actually a reference to clause 18, because there wouldn't be a need to define damage if you just left it in bold. So it's an attempt, in my submission. One looks at the schedule to the policy, which I ought to show the board, which one finds in the supplemental bundle at page 84. And one sees there a reference to business interruption, and then there is effectively an option of cover on the basis of estimated gross profit or estimated gross revenue, and it's been agreed in this schedule that the cover is in relation to estimated gross revenue. That's the basis of the cover. So there's a sum insured of 340,000, and then one then, if one goes back to 8.2.6, you've of course got to know when it says in 8.2.6, which indemnify expect to interruption to the business caused by damage as defined in clause 8.1. That is, in my respectful submission, a nonsense. But the pointing to 8.2.1 in respect to the extensions is trying to point you, if it has any purpose, to the fact that in 8.1.4 there is a formula as to how to calculate gross revenue or estimated gross revenue, which is the basis of loss. And our submission is clearly there is a mistake on the face of the instrument. If one looks, and I could take you through all the covers in 8.2.6, one is dealing there with cover where in all those paragraphs there is loss and damage caused by non-physical loss, caused by either authorities closing you down or stigma. There may be the odd rather anomalous case where there may be physical loss or damage, vermin or pest in the premises. It is possible, I have to accept, that vermin could eat through electrical cables, which cause close down. But in reality, the more common circumstances is that there is business interruption loss because either it becomes known that there were rats in this premises and people decide they don't want to go there, or because a local authority closes them down.
But Mr. Gruder, I mean, I think we've really got all
You've got that
points.
point.
We completely get those points. But the point I'm struggling with is if you say 8.1 points you to the reference to 8.1 points you to 8.1.4, for example, as to the calculation of gross revenue lost, then the word damage does not mean physical damage at all. It must mean loss.
Yes.
Now, if it means loss, it doesn't also mean insured perils.
No, it means...
So it's... Well, let me just
no,
finish.
my
You have
lord.
to sort of put your money...
No,
on
I
one-
put my money on that once you find that 8.1, the reference at the beginning of 8.2.6 to as defined in clause 8.1, either you just omit that or it points you to losses calculated in 8.1.4, those are alternatives. Once you get to that point, then you then construe damage in the other parts of the clause as insured peril. Because that's exactly what they did in the FCA test case, in the Irish case, and in Mr. Justice Jacobs' case.
But they were non-damage clauses.
They were not damage clauses, but of course, my lord, once I've sought to persuade you that 8.2.6 is also not a damage clause, and that when it says damage, as defined in clause 8.1, it's either to be ignored or points you to the calculation of loss at 8.1.4. Once you accept that, there is no problem in referring to the insurance in this clause will only apply a period beginning with the occurrence of the loss and ending not later than 3 months thereafter, in which the results of it shall be affected in consequence of the damage. Because at that point, you say it's an insured peril. This is a type of provision which very commonly appears in insurance policies, business interruption insurance policies, which provide business interruption cover for non-physical damage perils.
Well, which of your two possibilities are you putting forward? Because your first submission was that we simply strike out the words caused by damage as defined in clause 8.1, and your second is that you're relying on them, but it should be seen as a reference to 8.1.4, and those, it seems to me, are different. And how do we know which is the one?
Well, they are alternative arguments. My primary argument, Lord, is to say you strike it out because it doesn't make sense. It's meaningless because there is no definition of damage in 8.2.1, and these are clearly non-damage covers. But you know, if one has to give it a meaning, then that is the meaning. But my primary.
But you at least have to give it a consistent meaning, don't you?
No, my lord, because once one finds that damage as defined in clause 8.1 is in a sense meaningless because there is no such definition, and one finds what one realizes looking at 8.2.6 that this is non-damage cover, one then construes in consequence of the damage, or one construes the reference to in 8.1.4 8.1.4a on page 27 respect to the reduction of gross revenue, the amount by which the gross revenue during the indemnity period will, in consequence of the damage, fall short of the standard gross revenue, that, in my submission, you could construe there as insured peril, because you then realise if in 8.2.6 you realise that caused by damage as defined in clause 8.1 is effectively meaningless and is in a sense not only meaningless but repugnant to the purpose of the clause, you then realise you've got a non-damage cover, and then you construe damage consistent with the way it's construed in cases such as the FCA test case as meaning insured peril. In the other provision.
So your real argument is that the obvious mistake is to have provided damage cover when it was meant, because of all the provisions, the 5 provisions in 8.2.6 and 8.2.5 and 8.2.8 to provide non-damage cover. Now that is, at least I understand the point, but is it not really violating every rule of interpretation, which is that you don't just rewrite the contract for the parties and say, well, it says it's providing damage cover, but actually it's not. And quite clearly, you are changing it, and you can do that, but how you change it might be problematic, as Mr. Keeley has pointed out in his skeleton in some meticulous detail, that it gives detailed problems to the time that the cover lasts, when it starts and when it ends, and all that. How do we know how to rewrite the contract?
Because, my lord, if one starts off with the fact that once one realises that damage as defined in clause 8.1 makes no sense.
So that's
makes
your,
no
that's
sense
your
in
entry
itself,
point. Yeah.
and makes no sense in the context of this cover.
Mm-hmm.
One effectively omits that and says it's clearly a mistake, as it would be in relation to the other covers, because clause 8.1 talks about them being an insurance policy covering your interest and so on, which it wouldn't be covering loss or damage, which would not be the case in relation to some of the other the other covers in 8.2. Once one realises that makes no sense and is repugnant to the cover granted, and one effectively omits that, perhaps one then realises that this is a non-damage cover, and then when one looks at the insurance by for example, the end of clause 8.2.6, the insurance by this clause should only apply for the period beginning with the occurrence of the loss and ending not later than 3 months thereafter, in which the results of the business shall be affected in consequence of the damage. One realizes one then construes damage in that respect as insured peril, because that's exactly what they did in the FCA Supreme Court case, and but by the time it got to the Supreme Court, it was common ground by the time it got to the Supreme Court that reference to damage in that respect should be read as insured peril.
But that was because they were dealing with a non-damage cover. But
That's
here
right.
we're dealing with a damage cover on its face, and if you look at the authorities, they, something I said in this case of Brit, which nobody has ever looked at, but I said paragraph 33, the process of corrective construction adopted in the alternative by the judge is only normally adopted where there is really an obvious mistake on the face of the document. There's no obvious mistake here, as there was, for example, in Manai as to the date, or in Doe and Cox and Rowe as to the name of the pub, if you remember that wonderful case of Lord Ellenborough, where there was a sale contract about they sold a pub called the Red Lion, and it was actually called the Fox and Hounds. I don't know, but whatever. Now, what I'm troubled by, Mr. Gruder, because the court doesn't want to do stupid things. I completely understand your argument that the poor old insured, looking at this, probably wouldn't know what it meant, what it was trying to do, because it looks like a non-damage cover that requires damage, which is stupid, as you've told us in some colourful language. But it is damage cover, because that's what it says. And to change that, it's not absolutely clear how we provide non-damage cover on the grounds that was the obvious and only sustainable intention of the parties.
Well, there is in my respectful submission, and I'm probably repeating myself.
Yes, well, I think there's going to be an element of that, but you can repeat yourself a little bit longer.
There is an obvious mistake on the face of the document because it refers to as defined in clause 8.2.1. There is no such definition.
Yeah.
And what's more, my lord, what's more, my lord, one cannot. And again, you've got my points in relation to 8.2.6 that there are covers here, some of which are impossible.
But that's why it's not just 8.2.6. I mean, 8.2.5 and 8.2.8 are even on one analysis more stupid.
Well, they are.
So you have to literally rewrite the contract to make sense of it. But that's an exercise the court really doesn't do unless there's an obvious solution.
Well, the obvious solution...
Show me a case where they did rewrite one type of cover. It's because it often arises in insurance, reinsurance, where you rewrite one type of cover as another type of cover just because insurers have put in a clause which is incredibly difficult to understand or possibly meaningless.
Well, my lord, one has got the general principles in Chartbook.
Well, Chartbook is a very problematic case, as we know. I mean, to take the principles out of Chartbook and just assume nothing happens since Chartbook is not helpful, really. But I agree, 22 to 24 of Chartbook stand.
It stands. My lord, also one has the general principles as set out in East Pantile,
yes,
which again stands.
But they don't, East Pantile stands, but it's very problematic for you because there is more than one obvious, there's more than one way of rewriting it.
Well,
lots of ways of rewriting it.
Well,
you accept?
If I were to, once one sees, if one assumes you're with me, maybe you're not, that there is an obvious mistake.
Assume we're with you.
Assume you're with
for the
me.
purpose of
I do take the point that there should be, some authorities say, there should be only one way to rewrite.
Yeah.
And I would submit that once one has an obvious mistake, which in my submission is, I would submit that the fact that you might think of one or more than one way of rewriting it to more than one method to skin a cat does not mean that you should fail. So if you say to me, how would I rewrite it? What is your case? And if I had to put my money on one way, I would say in all of these covers, but in particular 8.2.6, but also in the others, in 8.2.5 and so on, you just ignore caused by damage as defined in clause 8.1.
So what I think you're saying is that you accept that there could be more than one way to rewrite it, but you say where there is an obvious mistake, you should rewrite it in the most sensible way.
In the most sensible way. The fact that you know, I might say, well, it's a reference to 8.1.4 if it's gross revenue. Well, that's a possibility. But,
and in the most sensible way, Mr. Gruder, sorry to interrupt you, but in the most sensible way that accords with the, you would say, obvious intention.
Obvious intention of the parties. And in my submission, the way one deals with it is one just reads 8.2.6. We shall indemnify you in respect of interruption of or interference with a business arising from. That's it, arising from those perils. And one would also...
Sorry, I didn't catch that.
So if one looks at 8.2.6
yes.
on page 29.
Yes. Oh, I see, arising from is in there already.
Arising from is already there. So one just takes out caused by damage as defined in clause 8.1, which indemnify in respect to interruption for its business arising from, and then A, B to E. The insurance by this clause shall apply to for the period beginning with the occurrence of the loss, ending not later than 3 months thereafter, in which the results of the business shall be affected in consequence of the damage. But when one gets, if I'm right, when one gets to that damage, at that point, one is dealing with a cover that is clearly a non-damage cover. The point is exactly the same as in the FCA test case. One then reads damage there as insured peril.
Yeah.
And one then, if one then goes to 8.1.4, if one then, in those circumstances, you say, well, it's gross revenue. How do you work out the loss? You then look at you apply the formula in 8.1.4. Our liability in respect of gross revenue, etc. Our liability under this section in respect of gross revenue will be, respect to reduction of gross revenue, the amount by which the gross revenue during the indemnity period will, in consequence of the damage. At that point, you read that as insured peril because of the fact that you are dealing with a non-damage cover. And the reference to damage in these type of calculation machinery of loss, you then read it as an insured peril because, as my Lord has seen in the FCA test case, the calculation machinery is written as if one is dealing with business interruption caused by damage to property. But when one is dealing with non-damage cover, one has to manipulate in order to make sense in the context of non-damage cover. So the crucial, if I may say so, my Lord, the crucial amendment or the crucial change to make is in the first 2 lines of 8.2.6.
That doesn't work, does it, for 8.2.5 or 8.2.8, because there, damage clearly does mean physical damage to either a neighbouring premises in 8.2.5 or to a supplier's premises in 8.2.8. So for those clauses, which you lump together with 8.2.6 as showing that the reference to defined in clause 8.1 is wrong, is an obvious mistake, the solution would have to be different.
The solution would, I think my Lord is right there, because if one looks at 8.2.5, if one says damage as defined in clause 8.1, you can't point you can't.
So the problem.
You can't look at 8.1.1 because the insured would never have a policy of insurance covering his supplier's premises or an electrical substation or what have you.
So the problem in 8.2.5 and 8.2.8, where the words are precisely the same as in 8.2.6, is not the word damage, but the words as defined in clause 8.1.
That's true. So that means what amendment or what correction by way of construction, or as the Master of the Rolls says, by way of interpretation, which is the right correction to make, depends upon the attributes of the particular extension. But I do accept that, for example, to take the supplier's cover at 8.2.8, in that context, one would just delete as defined in clause 8.1. I do accept that, but of course, that shows, if I may say so, how badly drafted this policy is, and that one has to make sense. I would accept, to make sense of this policy, or the extensions to this policy, one might have to make different corrections by way of construction in respect of different covers. Because 8.2.6 is a non-damage cover, we would say, but 8.2.8 or 8.2.9 depends upon damage to suppliers' premises or damage to electrical substations, etc. But of course, 8.1.1 would make a nonsense of those covers, because 8.1.1 requires or contemplates the insured will have a policy of insurance, which it will claim on, which of course it would never have a policy of insurance on an electrical substation, in which it has no insurable interest. So I think, if I can use a colloquialism, my Lord's point is right, that it shows what a total dog's breakfast this policy is. And one, having seen that the policy is a mess, in my submission, one sees that the policy 8.2.6 doesn't make sense, nor do some of the other extensions. Therefore, there's a clear mistake on the face of the document. The mistake may be different, I accept, depending upon which extension one looks at, and you have to make sense of this cover. And I would submit it is a counsel of despair to say that this policy is a nonsense, but one has to leave it as it is, because it then leaves an insured, if he's relying upon 8.2.6, with no effective cover, or if the insured wants to rely upon 8.2.8 or 9, to say, well, I'm sorry, you can't, even though there was a fire at your supplier's premises and you can't serve any pizzas to any of your customers because you can't get any, I'm very sorry, you can't have any cover because you didn't have a policy of insurance on your supplier's premises, which of course doesn't make any sense. So what one is dealing here with a deeply flawed policy, which clearly there has to be a correction if one is looking at 8.2.6 in order to make sense of the policy. And in my submission, my suggested correction is the correct one, that one reads it as which indemnifies for interruption to the business arising from. But I do accept the corrections may be different depending upon the different different extension. So, my lord, in relation to the authorities, we say in the context, if it's clear something has gone seriously wrong with the drafting of the policy, which we say there clearly is something seriously wrong, the next question is what would a reasonable person have understood the parties to have meant? And my submission, my solution is the correct one. And one has got, for example, Lord Justice Lewison in Honda Motor, which we, I think, refer to in our skeleton argument, which is at page 66 of the authorities. Where that's at paragraph 37. He says, in my judgment, it's still necessary in order to invoke this principle that something should have gone wrong with the language as opposed to the implementation of the bargain. Well, we don't say that there was some bargain that has been wrongly written, wrongly implemented, or the relevant decision to exercise powers. The typical case in which the principle applies is where the clause in question is an obvious nonsense. In addition, even where the principle is invoked, the question remains, what is the meaning the instrument would convey to the reasonable reader? Well, I've sought to persuade my lords that the instrument policy is an obvious nonsense. And we say, well, the meaning which clause 8.2.6 would convey to the reasonable reader is the meaning I've sought to put forward, which is something which I've adumbrated at some length. And we say, actually, it was these principles, the principle of correction by way of construction, which the Divisional Court, Supreme Court applied in the FCA test case in rejecting the requirement for damage before a trend clause applied to the quantification of business interruption loss arising from the COVID-19 pandemic. And I should deal with one argument which appears in Bellini Friend's skeleton argument, which is, it seems to suggest that we could have paid for insurance with non-damage cover, that somehow there was a choice to get this policy, which referred in clause 8.2.6 to damage, or to get a policy which didn't require for damage. Now, we submit there's no evidence whatsoever of that. Now, some policies do not have extensions at all. That is possible. And some policies have extensions which provide cover for business interruption without property damage, e.g. There are covers which for infectious disease or prevention of access by authorities due to dangers or disturbance within 1 mile of the premises. But Brit seems to suggest that there is a choice available between extensions which provide cover for business interruption caused by infectious disease or other perils in clause 8.26, and those which only cause business interruption if there's damage to property caused by an infectious disease. And we say that's absurd, that there is no such choice. We say the Brit policy is really an anomaly. It's incompetently drafted. And the idea that they seem to suggest that the broker was faced with a choice and deliberately chose cover where there was cover with perils set out in clause 8.2.6, which they say was dependent upon physical damage. And we say that's absolutely unsupported by evidence. There's no evidence here of any negotiation or back and forth, which says, oh, well, you can have 8.2.6, which talks about damage, but if you pay a bit more, you can have effectively 8.2.6, or the cover set out there, without a requirement of damage. This was, as my lords have seen, 8.2.6 was part of a standard form printed policy where the premium was with you £2,270.60, including insurance premium tax.
Mr. Gruder, isn't there a finding of fact against you on this in paragraph 26 of the judgment?
Well, the finding is based upon what one needs to look at the agreed facts, and the finding can only be based upon the agreed facts. There was no oral evidence, and the agreed facts are paragraphs 3 and 4 at page 118. Of the core bundle, page 118. Sorry, the supplemental bundle, I think. So, the agreed facts at 118. One, the parties agree the background to the COVID pandemic. As set out in the FCA. All the facts below relate to time the policy was concluded. Clause 8.2.6 automatically included in the policy as standard. No additional premium was paid for it. Well, that's actually the position with all extensions, but that's fair enough. In general terms, without passing comment, one way or the other on the policy involved. Sorry?
It's not the position with all extensions. That is wrong.
In general terms, and without passing comment one way or the other of the policy involved in this case, business interruption insurance was contingent upon the occurrence of physical loss and damage to the insured premises or other property. That's the standard cover. Non-damage business interruption insurance was also available as an extension to standard business interruption cover, which was not contingent on physical loss or damage to the property, providing various forms, one of which was in the former extension on similar terms to clause 8.21, which did not expressly require physical damage. Examples of such cover were seen in the FCA test case, see the judgment divisional court. So those are covers provided by other insurers, such as QBE, RSA, etc., etc. The premises, and then it sets out the premises were such and such. 6, the claimant was represented by an insurance broker. The claimant's insurance broker placed the policy through a Lloyd's managing agent. Fair enough. And not which accepted business only through professional intermediary and not directly from members of the public. Accordingly, any business placed through generation necessarily involved an expert intermediary. So the facts really are set out in paragraph 4, but that doesn't say that there were. It says that there were covers available which did not refer to damage, and then it refers to cases or to examples in the FCA test case, which are ex hypothesi cases, covers provided by other companies. But it doesn't in any way provide any evidence that was any kind of negotiation or back and forth which says, well, do you want a cover which refers to damage, to infectious diseases causing damage, or do you want a cover which doesn't refer to damage? There's no evidence that there was any kind of back and forth.
Would such evidence be admissible?
Probably not, but the other side, are seeking to make something of it in their skeleton, and I'm trying to deal with that. And of course, the answer to this, and indeed, really the other side give the answer to this in paragraph 56 of their skeleton, is that before this policy was taken out at the end of 2019, before the pandemic, as they themselves say, nobody focused on these extensions at all. It's only after the pandemic, after the government regulations, which closed down various businesses, as my lords know, that obviously there was a laser focus on extensions such as these. But at the time the policy was taken out, as they themselves accept in paragraph 56, there wasn't an enormous consideration of, oh, do I have an infectious disease extension dependent upon damage or not damage? I mean, whether that's admissible or not, I take my lord's point, but it is a point the other side have made, which I thought it right to deal with. So, my lord, we say, and I'm that we ought to allow our appeal. It's submitted that the judge's decision was wrong, that cover under clause 8.2.6 is not dependent upon proving that an infectious disease within 25 miles of the premises caused physical damage. We say the judgment below should be reversed, and unless I can assist you further, those are my submissions.
Thank you very much, Mr. Green. Mr. Keeler.
My lords, if you go to paragraph 56 in the core bundle at page 57, just worth reading quickly.
56 of?
Paragraph 56 of our skeleton article for your lordships, at page 57 of the core bundle. Just to make this point clear, if I might. What your lordships have, without having to go to it, is the FCA test case, where what the FCA did was to choose a lot of policy terms, which were all non-damage policy terms, which the FCA expected or hoped would cover what had happened as a result of COVID, and have those policy terms dissected and analysed and construed by, firstly, the Divisional Court, and on appeal by insurers, by the Supreme Court. And as my learned friend has acknowledged, and I'm therefore not going to take your lordships to where it is, standard BI cover is parasitic upon physical damage. That is typical standard BI cover. It is therefore not typical and not normal to have non-damage BI cover. The only reason why the FCA wanted to go to the Divisional Court to have these matters dealt with was because on the terms of the non-damage BI cover, there was a real possibility of coverage. None of the cases put before the Divisional Court was on standard typical BI cover terms, which are dependent upon the existence of physical damage. What we say in paragraph 56 of our skeleton is that this is a paradigm case of, if anything, an error of negotiation, not an error of language. What we're saying is that Bellini's broker could have placed, and obviously it could have, if it found an insurer willing to insure it, BI insurance on terms which included non-damage cover. We're not suggesting that Bellini had to come to us and negotiate with us, but they had a whole panoply of possibilities out there. There were, I think, either 11 or 9 insurers before the Divisional Court and the Supreme Court, and those were a selection of a large greater number of insurers whose names were either happily for them or unhappily for them not chosen or selected to be involved in the litigation. We say many examples of this kind of cover were seen in the FCA test case. For whatever reason, Bellini did not pay for, which is correct, or obtain, and that is arguable, non-damage cover. That's not a drafting error, and that's very much the basis of our case. We're not dealing here with an error of drafting. I'm going to go to Lord Justice Brightman's judgment in a moment, because he quotes with approval an important passage that your lordships will be familiar with from Snell's Equity, which explains the position rather better than I can. If Bellini, with hindsight, wishes it had obtained non-damage cover, it or its broker's failure to do so was an error of negotiation. I'm not saying that there was toing and froing with my clients, or commercial intuition. These are the words of Lord Justice Ricks. And then we go on. And we accept it is quite probable that Bellini and or its brokers didn't even consider the need for non-damage disease cover, because it's rarely at the forefront of people's minds, or was, before the COVID-19 pandemic, at least in the Western world. Of course, one knows in the Far Eastern world, the contrary was the case, which is why you have such little litigation in the Far East in relation to COVID, because they'd already had the considerable experience of SARS about 15 to 20 years earlier, and all the insurers out there had done, as it were, for themselves, what they considered to be the right thing. In that case, this is a case of Bellini, in that sense, this is a case of Bellini or its broker failing to anticipate the consequences of the language which the parties used, as Lord Justice Carnworth described the bank's failure in Ros Roca. It's not a genuine drafting error. It's a case of the insured buying cover, which is clearly for X, and I'll come back to that, and later wishing it had cover for Y, and that doesn't permit correction of the contract, because that's amount to judicial rewriting of the sort which is clearly forbidden. Now, before I go on, I just wanted to pick that up before I forgot it, because my learned friend, as it were, ended his submissions on that note. What I want to say, however, my lord, is that we have never understood until today exactly what it is that my learned friend's clients, Bellini, wanted, as it were, to have done with 8.2.6 in order to achieve its objectives. If one goes, my lord, to our skeleton, the same bundle, the core bundle, and this time one goes to paragraph 45, at page 53 of the core bundle, and if I'm to be corrected, I'm happy to be corrected. Second line, Bellini fails to identify what the so-called error is said to be. It simply asserts repeatedly that an error was made without identifying what the error actually was. And then we say that the law requires a clear drafting error, and Bellini appears unable to say what it was. Its case may be that the error was the very inclusion in clause 8.2.6 of the words caused by damage as defined in clause 8.1 arising from, and or in the penultimate paragraph in consequence of the damage, or perhaps the use in these phrases of the defined term damage, or the failure to use the insured perils in place of damage, or the failure to carve out a bespoke definition of damage for the purposes of 8.2.6. Brit will wait to hear whether Bellini identifies what precisely it says the error was, but its own case is that there was no drafting mistake. That's my clients. If one goes back, my lords, to my learned friend's skeleton in the core bundle at divider 3 at page 32.
Which paragraph?
Paragraph 47. And this is perhaps what has misled me so far into not understanding that my learned friend was going to make the submissions that he's just made this morning. At 47, the skeleton says, clause 8.1 also goes on to define in subclauses 8.1.2, .3 and 4, etc., the method of calculating how much is payable under the provisions of Section E. Those methods for calculating the amount of indemnity, such as gross revenue, estimated gross revenue, are applicable not only to the standard cover, but also to the extensions. And then if one turns to paragraph 48, when the extensions under 8.2 refer back to clause 8.1, they are therefore not referring back to some specific aspect of damage, as Brit pleads, such as whether it's physical in nature. They are referring back to damage in its entirety in the context of 8.1. The extensions, by doing so, are acting like extensions would be expected to act. I think there's a drafting error because I think there perhaps should be a colon or a semicolon. They are restating the machinery of the standard cover and then extending it to things not already covered by it. So our understanding was, in fact, until this moment, that the reference back to 8.1 in 8.2.6 was regarded by my learned friend as entirely appropriate and not as entirely inappropriate. It is now said by my learned friend, and I don't think this has ever been said before, that the reference back to 8.1 in 8.2 or 8.2.6 specifically is inapposite because, it is said, the provisos in 8.1 cannot apply. If one goes, if my lords could, to the insurance policy in the supplemental bundle at page 26 to clause 8.1.1, what he is saying is, remembering 8.2.6, he is saying that the references back to 8.1.1 or 8.1 are inapposite because of the provisos which appear at little a and little b for that matter. In other words, provided that at the time the damage occurs there is in force either cover under the sections, buildings or contents, or an insurance policy covering the interest of you in the property at the premises against such damage and such property is of a type and kind not excluded by the section, and then little b goes on the same theme. That is a completely new argument, and moreover, its novelty is not actually improved by its quality. Because these are provisos. They're not part of 8.1 other than in relation to they are additional conditions to the application of the substantive indemnity or insuring clause in the first paragraph of 8.1.1.
I mean, I thought he said that it was inapposite because 8.1 doesn't define damage.
Well, that's another possibility. I'll go on to that in a minute. If it is inapposite, then there are a number of solutions, my lord. Firstly, one removes the words as defined in 8.1, which I don't actually approve of, and I'll tell you why. And one retains the word damage, because damage on any view in 8.2.6 and in all the other places in 8.2 that it appears is an emboldened word, which, as anybody knows, looking at an insurance policy or any other contract of that character, guarantees or indemnities, is normally in bold because it is a defined term, and one therefore, even if one strikes out the words as inapposite, as defined in 8.1, one remains with the word damage in bold. If one wants to play around, and I'm not suggesting that your lordships should, but if in a sense one says, well, it says as defined in, and that qualifies the word damage, then as my learned friend said, and I acknowledge, you don't need to say as defined in 8.16 because damage is already emboldened. But if you do want to have consistency of that character, and one is concerned to say that there is an error in drafting. The error in drafting, rather like your lordship's case, the Brit case, or other cases, there is a Rocker case, is an error in drafting. In other words, it's almost like a word processing error. And one simply changes 8.1 to 18.16, where the definition appears. But in fact, what is important about 8.1, and the reason why this isn't merely a drafting error, is that the business in 8.1 is the business carried on by you at the premises, and secondly, the damage must have occurred during the period of insurance. And as we say in our skeleton, my lords, and we say this at, I think it is, I'll get you the reference. As we say it in our skeleton, I think it is in paragraph 22, which is the core bundle, divider 424. The words as defined in clause 8.1 do not just qualify damage, they qualify that which appears before. And the reason why they qualify that which appears before is if one goes back to 8.1.1, there must be damage. We can, obviously 8.2 takes precedence over property used by you at the premises. There must be damage, but it must be during the period of insurance, and the consequence is that the business carried on by you at the premises, not somewhere else, but at the premises, is interrupted or interfered with.
Sorry, where are you reading?
I was reading, actually, in that context, from 8.1.1 at page 26.
Yeah, but the point about qualification is you say that in 8.2.6, it's we shall indemnify you in respect of interruption of or interference with the business caused by damage as defined in clause 8.1. The as defined in 8.1 is referring to interruption of or interference with the business caused by damage.
Indeed it is, and it's referring to interruption or interference with the business carried on by you at the premises, which are the words of 8.1, caused by damage during the period of insurance, as set out in 8.1. In other words, it can't be just caused by damage generally. It can't be, you can't have the business interruption loss. Let me put it this way. What you can't have is the business interruption loss during the period of insurance, but caused by damage before the period of insurance. So the damage must occur, this is if you go back to 8.1, the damage must occur during the period of the insurance for the coverage to be engaged, and that is 8.1.1. Otherwise, an insured could come along and say, well, the policy starts on the 1st of December, say, I had an incident on the 1st of November, I've got business interruption loss during the period of the insurance, I'm entitled to coverage.
So you say this is all a bit of a bootstraps argument because it assumes what it sets out to prove, which is that this was intended to be non-damage cover, when if it's read fairly, it's perfectly clear that this is all about damage cover to business interruption.
It's all about damage cover. And I was going to start there with my submissions. Your lordships have read my long skeleton. Mr. Wright drafted it brilliantly, and I simply signed at the bottom line after making one or two.
Well, Mr. Keeley, I doubt that because there are one or two lines in there that I suspect you interposed yourself.
Perhaps. I also eliminated, my lord, all the drafting errors, so that your lordships wouldn't be. There's one, though, but your lordship. Can I just actually pinpoint one drafting error in my learned friend's skeleton, which is ripe for Chartbrook and Persimmon correction? If your lordships go to core bundle divider 3 at page 35.
Which para?
I'm so sorry, just say paragraph 61. Now, I was very troubled by this. It caused me some psychological challenges and problems in determining what should be omitted and what should be deleted and what should be added. Your lordships immediately see the drafting error.
It's the split infinitive, I assume.
Well, as well. A reader with sufficient experience of the skeleton argument would inevitably say to themselves, of course, the word was should not be there. Or, if it must be there, it should be followed by the word led or even misled, and the word fell must be removed, and parts of the remainder of the sentence revised accordingly. Now that is a Chartbrook and Persimmon error. The substantive error in my learned friend's case it is, however, not this. It's not one of language. It assumes throughout, and we've gone on about this at length in our skeleton, it assumes throughout that clause 8.2.6 was objectively, of course, intended by the parties on any reasonable interpretation of their intentions to provide non-damage cover. And one sees that at paragraph 60 of my learned friend's skeleton, at core, divider 3, page 35, immediately above the error in drafting to which I took your lordships a moment ago. Because there, the judge below is criticised for not construing the term damage in such a way as to correct what was an obvious error, which was not intended by the parties on any reasonable interpretation of their intentions, to confine wide-ranging disease cover to circumstances where physical property damage occurred. Now, I'm going to take your lordships in a moment to some examples of where clause 8.2.6 does have perfectly reasonable application. I accept straight away that the application of 8.2.6 is not going to be a typical or common event. But even assuming that 8.2.6 has no practical application in the world as we know it, that does not give your lordships permission or authority to reconstruct the contract in the way that my learned friend would like it to be reconstructed, or in a way that your lordships consider it might be fair and reasonable if one were starting all over again, and let's see what we can do and protect people against COVID-19 in the future. The first matter, my lord, is that this insurance and clause 8.2.6, they are not a one-off. They happen actually, that clause 8.2.6 happens actually to appear in many of my clients' contracts, but not only in my clients' contracts. There is at least one case before the Financial Ombudsman which she decided between parties other than my clients and insureds, other obviously than Bellini, where the clause 8.2.6, I'll take your lordships to the relevant references in a minute, the clause should not be removed, deleted, altered in any way, and shouldn't be construed in the manner contended for by insureds. I'm of course familiar that your lordships aren't bound by what the Financial Ombudsman determined, but she was not, as it were, unconcerned about the consequences of what she was doing. If your lordships could go to the skeleton below, not the skeleton, this is my client's skeleton below, not the skeleton here, which is the core, divider 10, not the core, is it, or is it the core? Yes, core, divider 10, forgive me. At page 96, to paragraph 30, the Financial Ombudsman Service has decided in no fewer than 8 cases that Brit's construction is correct. In each of those cases, the Ombudsman dismissed complaints by policyholders who said they were entitled to cover under a clause that was identical to 8.2.6 in the absence of physical damage to property. In every case, the insurer declined cover on the basis that there had been no physical damage to property. The FOS upheld these declinatures, etc. A deciding clause did not on its clear terms provide coverage in the absence of physical loss of damage. For example, in the policyholder's complaint, she said, I think for the extension to provide cover, the interruption to the business must be caused by a physical loss, physical damage, or physical destruction. I've considered what a reasonable reader, with all the background knowledge which would reasonably have been available to them, would reasonably have thought when entering into the contract. Having done so, in my view, the wording of the policy is clear to the parties entering into the contract that there is a requirement for damage to have occurred in order for the extension to apply. Given that I think it's likely the policy was intended to provide cover in the way it was drafted, that there isn't an obvious error, that the meaning is clear, and that this is the agreement the policyholder and the insurer entered into, I don't think it would produce a fair and reasonable outcome for me to uphold this complaint. And then, if your lordships could turn on to paragraph 48 in the same document, actually, I don't need to read that. Well, I shall, if I may. Another passage from the Ombudsman in a different case, at the top of page 103. In my view, given the meaning of the clause is clear that parts of it provide limited cover, isn't a reason to conclude that it should be interpreted as a non-damage denial of access clause. I accept that the cover provided by this part of the clause appears limited, but for the reasons set out in my provisional decision, I don't believe that's a reason to rewrite the clause to provide cover without damage occurring. My lords, I echo those sentiments as part of my submissions. And even taking the case against me as extreme as it could be, assume that 8.2.6 provides no cover at all. That is not a reason for not giving it the meaning that it demands. Insurance contracts are replete with redundancies, and your lordships will know, probably from your own home insurance policies, that some of those clauses might not give cover in circumstances when you would hope that they should. But insurance is a contract, it's a bargain of the distribution of risk. If the parties have clearly and unambiguously distributed that risk, even in such a way as to mean that in certain circumstances the insured has no coverage, that doesn't mean that the courts should say otherwise. And I would go on further to say that there is no presumption that a clause, an insuring clause in a contract, gives wide coverage or generous coverage, narrow coverage, or coverage at all. You think that it will, you hope that it will, but there's no presumption that it will.
Is that right? If there's a clause in a contract, never mind whether it's an insurance contract or not, but take an insurance contract, I don't really see how the principles can differ, which on the face of it purports to give cover, that's what the clause is doing, it's setting out cover, but on analysis produces no cover. Can't one say that that is, whether you call it a presumption or not, if you see a clause, this clause in this case, it says 8.2.6, murder, suicide, or disease, it's clearly providing cover of some kind. And if you came to the conclusion it provided no cover at all, something's gone wrong, hasn't it?
No, I'm afraid not. Depends. If I were the insured, if I were the insured, I'd be afraid not.
Right.
But
no.
If you're the insurer, you say it's the perfect clause, I suppose.
Well, you'd say if you're the insurer that if that's what the clause means objectively, doesn't matter about there's this debate, as you see in the authorities. I think your lordships or one of your lordships probably been involved in one of these debates about the difference between what are the intentions of the parties, and does one actually analyse construction by reference to the objective intentions of the parties, or does one actually analyse a contract by reference to the objective meaning of the contract, not talking about intentions, because intentions are slightly diverting and perhaps are not the right way of looking at it. And you look at the books and you look at the authorities, and it's an entertaining and intellectual exercise. But, and probably one doesn't look at the intentions of the parties. What you're looking for is objectively the meaning of the contract, or the meaning of the term, in the context in which it appears to a reasonable reader, with all the resources, etc., reasonably available to him, it, her, whatever it happens to be. That's what you do. If the clause actually provides assume no cover, then it's not for the court to say, I'm now going to do à l'américaine in certain states of America. I'm now going to find an ambiguity when there is no ambiguity, in order to provide cover when there is no cover.
Can't one say, well, there must be something wrong because it purports to give cover and doesn't give any?
No, because
When can there ever be something wrong then?
Well, no, you can't say it purports to give cover unless it actually provides cover.
Well, you can, can't you? Because you can see a clause that says it's an insurance contract that starts with the words, we will indemnify you. That seems a pretty clear indication that it's providing cover of some kind.
That is a pretty clear...
Purports to provide
purports.
cover.
I stand corrected. I stand corrected. You assume that it will be providing some cover, unless you're driven to the conclusion to the contrary. By reason of, it's rather like what Lord Neuberger said, I think it was Arnold in Britain. He said the fact that, for example, a contract as a whole, rather than just one clause out of millions of clauses or thousands of clauses, contract as a whole produces a disastrous result. Doesn't mean to say that the court can do something about it.
Well, I agree, but that's not quite the same thing as doing nothing when a clause purports to do something.
Well, I take a stricter view, but I'm probably wrong. But let's put that to one side, if I may, for the moment. I might have to be corrected, but I'll think about that some more, if I may. Let me put it this way. It's slightly different, but at least the argument is partly made good by the following. Your lordships probably have some form of buildings insurance for your houses, homes, whatever they are, caravans, I don't know. That will probably protect you against physical damage to the buildings and to the contents. It won't normally protect you against loss of use, unless the loss of use was caused by physical damage to your home and contents. Standard stuff. This is not an idle example. There is a volcanic cloud, say. The volcanic cloud deposits dust. The deposit of dust, if excessive, as a matter of English law, Hunter and Canary Wharf in the Court of Appeal, if in excessive quantities, is a form of physical damage. The reason why it's a form of physical damage is, even though it can be cleaned, nevertheless, it alters the physical state of whatever it alights upon, and it with an implication of harm being caused to it, either because it has to be cleaned off, or because if it's a contaminant, it has to be done so at expense. So that's physical damage. Your home, fortunately for you, is at the end of the road, and it never actually is affected by the volcanic dust. However, all the other homes in the street, up to your home, are. They all have the insurance. They all have to vacate their homes, and the people who live there, and go and stay in hotels, etc., and they incur costs and expenditure in relation to cleaning their homes, because they can't live there. You can't live in your home either, by the way, because it is surrounded by dust, although your home is pristine, surrounded by dust. In other words, the volcanic dust just hasn't got to your home, but you lose the use of your home. Now, many people, insureds, will say, well, that's terribly unfair. In a way, it is. Why should all these people who've suffered physical damage have full indemnity, whereas I, go and stay at the Claridge's or wherever it is, and I have to pay £1,000 a night, as do all my friends. But I don't get my £1,000 a night back, but they all do. And that can't have been expected. That can't be right. Well, the answer to that is, of course it's right. The bargain you made with your insurer didn't give you coverage, because contracts of insurance don't always provide coverage for all eventualities, even though by happenstance you actually haven't suffered the insured peril that you would need to have suffered in order to recover the loss, which is identical to the loss that you have suffered in any event. And that's because insurance is a creature of distribution of risk. Coming back to our contract, which is in the supplemental bundle at Divider 1, I shall remind your lordships that what is described by my learned friend as the requirement of damage in 8.2.6 as being the result of, quote, sloppy and unthinking draftsmanship, is in fact in complete lockstep, as we put it, with all the other insuring clauses in section E, bar one specific sentence and one specific insuring clause, which makes it clear that coverage does not depend on physical damage at all. But before turning to clause 8, one should put oneself into the position of the reasonable and conscientious reader. And normally that reader starts at the beginning. But before I start with the beginning, I'll remind your lordships that there are more than 300 references to damage emboldened in this contract. 8.2.6 contains less than 1%. And I'll also remind your lordships, when you come to consider my learned friend's submissions, which is, oh, this is terrible, 8.2.6 doesn't provide the cover that we objectively intended to provide, that is one clause among a number of sections that provide substantive cover. And I should also remind your lordships, when your lordships consider, which you don't have to actually, the fairness and reasonableness of what I'm saying, there is no excess applicable to BI cover. Your lordships get that from the schedule, which is in supplemental bundle, divider 2, page 84. There is no excess. Cover is from the ground up. So if the restaurant suffers a business interruption that it is able to prove, costing it, as it were, by way of loss, £10, it recovers £10. In fact, the excesses under the other sections are very, very modest, and I'm not complaining about that. I'm just telling your lordships what the position is. So, for example, under property insured at page 83, there is a small excess. Your lordships will see at the middle of the page, £250 increasing to £1,000 in respect of substance. Specified business equipment is not actually insured. Buildings are insured. There's an excess of 250, increasing to 1,000. Section D, computer breakdown, no excess. Section E, no excess. Terrorism not insured. Over the page to page 85, goods in transit, £100 excess. And at the bottom of the page, public and products liability, excess applicable 250, but none applicable to employers' liability. So before you start thinking about wide cover, narrow cover, whatever it is, whatever adjectival epithet your lordships might like to entertain in your lordships' minds or on paper, just bear that in mind. One starts at the beginning if one's a reasonable reader, and one goes to page 2 of the bundle, supplemental bundle in divider 1, and you see the contents. It is a package policy with a menu of coverage. And at clause 1.2, because you're turning the pages, because you're a conscientious reader, and don't forget, my lords, we have here expert intermediaries. Page 3 of the bundle, and you're reading it, my lords, and you're relatively conscientious, and you immediately see this agreement, and you read that, and you say, well, that's pretty boring. And then you go on to the next one, words in bold, and you think, oh, and you better read that because there are so many bold words, or emboldened words. Words in bold typeface used in this policy document, other than in their headings, have specific meanings attached to them as set out in the general definitions and interpretation. And you turn back a page, because that's what you normally do. You don't want to go scrolling through, because you've got a contents page, and general definitions are actually at contents 18, 3 from the bottom, and you know that they begin at page 68 because that's what it tells you. And so, because you know where it starts, and you see the word policy emboldened, you say, gosh, that's the first one that I've really looked at, because the up above, I can see that. I'll go to that if I have to, but let's just see what they say about policy. You go to page 74, 73, is it? 73, forgive me. And it tells you what the policy is at the bottom, 18.49. But you know two things straight away, and this is going to guide you throughout your reading of the document. Anything in bold, if you want to know what it means, go to the definitions. Headlines or headings, they've told you, I'm not a lawyer, so I'm not exactly sure what legal impact this has, but I'm being told that words in the headings, which are emboldened, don't have those specific meanings. So in relation to the headings, I mustn't, when it goes, for example, to 1.3 policy structure, I know that that is emboldened, but that won't have a meaning attached to it. If it does, I'm not bound by it. But when you go to the definitions, you will go to page 68 of the bundle, and you go there because you're curious, because you're a conscientious reader with some intellectual curiosity. And so you look at the top of the page, and it says the following words will have the same meaning attached each time they appear in this policy in bold typeface, whether with a capital first letter or not. And then you read the usual stuff about plurals and singulars and feminines and neuters and things like that. And then you come to the last sentence of the second paragraph. All headings within the policy are included for convenience only and will not form part of this policy. And then you look at, for section E, you see that there is something about section E, but that's not terribly important to you because you're taking out the policy and you're not that interested at the moment. But if you're curious at this stage, which you probably aren't because you haven't come across the word damage, but you're about to for the first out of more than 300 times, you will look at page 70 and you will see what the damage is. And you will see, for example, that it's physical loss, physical damage, physical destruction. In other words, it's not just loss and damage, it's not just financial loss. And then you'll see, oh good, in respect of sections I and J, loss of use of tangible property that has been lost. In other words, there is some loss of use protection, but only in relation to sections I and J, which are liability sections. Just to tell you.
It doesn't say property, does it, in 18.16.1?
No, no, it doesn't. But it obviously has to be tangible property because it has to be physical. It could be to a painting, could be to the patterner on a piece of furniture. It could be to a table, it could be to a bar, it could be to utensils, it could be to equipment. I'll come on to that when I come to 8.2.6 very quickly. But your lordships will know, because do you remember at the beginning of the COVID saga, your lordships were probably told not to stroke your other people's dogs, or your lordships were told when you go shopping to, let's call it, Asda, and you collected your shopping in a bag, and you brought the shopping back home, you were required, and you obviously did it personally, to use disinfectant towels to clean all the containers that you had touched or other people had touched from Asda, so that you wouldn't receive COVID in the risk that COVID was being, the virus that is, SARS-CoV-2 was being transmitted through surfaces. Not an idle injunction. COVID-19, or rather the virus SARS-CoV-2, is what is regarded as transmissible through fomites. Fomites are inanimate objects, by reference to which, or via which, infections and viruses and other things like bacteria can be transmitted. The reason why you were told to clean your whatever it is of tomatoes finest was because a lot of people will have handled that, and who knows, that might have retained the SARS-CoV-2 virus or virus particles all over it. And if you touched it and then put your fingers into your eyes or your mouth or whatever it is, if your children did that, if your grandchildren did that, that is a COVID-19 risk. And, since we're on to this interesting subject, this applies equally to anthrax, to mumps, to measles, to bloody diarrhea, which is another notifiable disease. It applies very much to norovirus, which is not a notifiable disease, but as you know, afflicted the fat duck, which is probably where you go for your snacks every evening. The fat duck, which meant that they had to close down. I'm going to come back to that as an example of 8.2.6 applying with force. You'll see that in a minute, because what happened in the fat duck was that contaminated oysters and clams were brought in. They were handled by waiters, because we're talking about a restaurant, obviously this is pertinent. They were handled by cooks and waiters and everything, and all the surfaces, including the tables, the counters, the kitchen, all the equipment, they were all contaminated with norovirus. People then touched those and transmitted it on, and transmitted it to other non-norovirus infected produce which came into the restaurant. And your lordships already know it was shut down for weeks, and there was a hullabaloo, and there was worry about losing Michelin stars and all the rest of it, but the restaurant not only survived, but reacquired all its Michelin stars within about 2 seconds once it started going again. Now that's an example of contaminated produce entering the restaurant. If someone with norovirus, let's call it 100 miles away, touches the oysters, which are destined for the fat duck, that person may well contaminate those oysters, which are then refrigerated. The virus is therefore, as it were, preserved, and it comes all the way to the fat duck and will then contaminate and damage not only people, but also things, property, at the fat duck. Now,
so does physical damage in clause 18.16 include people, damage to people?
I don't think so, because I think this contract talks about bodily injury. And I think that if I were looking at it fairly, which I am, at 18.8, which is page 69, you will see that a reasonable reader would say, no, I think when it talks about physical damage, or when it talks about damage and it's talking about physical loss, physical damage, and physical destruction, it's probably not talking about people being destroyed or people being lost or damaged. It's probably talking about property. That's my immediate reaction, my lord. I can't say that I've researched this specifically, but that would be my immediate reaction as someone who's read an insurance policy or two involving property damage and bodily injury as differentiated creatures of insurance law. So whether if you're lost, as it were, in the Pennines, that is a form of bodily injury, I doubt. But coming back, we then go, my lords, to section A. First section, it's going to be very important to anyone having this type of policy, because that person will say, I better have a look at the first section, contents, property insured, and then 3.1 tells you what are or what is, should I say, the property insured. So that person knows that it's fairly well protected in terms of the subject matter of the insurance. And then the next page, page 7, 3.2, is the first reference, I think, to damage. And that's what you're indemnified against. And there are a whole lot of perils there. Unsurprisingly, none of those will be, and this is unsurprising, it's not a point I take in my favour, it's unsurprisingly, none of those will be caused by local or central government authorities. There is, however, as your lordships will see, it's referred to in our skeleton argument, 3.2.9, that's an exclusion, or rather, sorry, it's an included peril, but it excludes. So an included peril is any other accidental damage occurring in the building, so that's quite wide, excluding little d, damage caused by or resulting from little 1, vermin and insects. Just bear that in mind, because we know that in 18.2, 0.6 at little c, what is insured is damage caused by vermin or pests in the premises. And if you follow the logic of the Supreme Court when dealing with a QBE argument in FCA, the inclusion at 8.2.6 will almost certainly trump the purported exclusion in 3.2. Now, I'm not going to go through much of this because all I'm going to invite you to do in the quietness of your own rooms, if you have any interest, which I don't suppose you do, is to go through each of the sections, and you will see that each of the sections will be a section which covers damage. So I've taken you to section A. Section B, at page 14 of this bundle, which I hasten to add is not insured if you look at the schedule, but 4.1.1, we shall indemnify you against damage, excluding a whole lot of damages. Section C, at page 15 of the bundle, buildings insured, damage, insured perils, 5.2, damage. Section D, by the way, buildings was covered, small excess. Section D at page 19, computer breakdown, damage. Section E, we've looked at this because it's 8.1. It doesn't matter. It begins 8.1.1, damage. And if you really want to be interested in damage, you go back to section 7 at page 21. Headed coverage clauses applicable to sections A, C and D, 7.1. European Community and Public Authorities, including undamaged property. And if you want to know more about that, you go to 7.1.1, and it talks about reinstating various items of property to comply with the stipulations. And because your eyes are good, you immediately see in bold the word damaged at 7.1.1b little one. In other words, these are the stipulations of the European Community legislation of buildings, etc., in respect of the damaged property thereby insured, and 2, undamaged portions thereof. Whoever drafted this certainly knew the difference between damage and non-damage. Coming back to business interruption, I'm going to come back to that. Terrorism at page 31, damage by way of an act of terrorism. Goods in transit, I should say terrorism was not insured. Goods in transit, G, was insured. Damage to goods in transit. That's at page 33. Loss of license in H at page 35 was not insured. And that's obviously loss of license, which doesn't depend upon damage. And then you have, it's nothing to do with damage, nor is section I employer's liability. It's to do with physical injury. If your lordships look at page 37 of the bundle. Will insure you against all sums you shall become legally liable to pay as damages, including claimant costs, etc., arising out of bodily injury. Not damage, my lord, in answer to your question to distinguish between bodily injury and damage. Section J is, however, dependent upon damage. That's at page 41. This is public and products liability, so it's not surprising. It covers at 13.1.1 bodily injury to any person and damage to tangible property. So if I were an imaginative lawyer, which I'm not, I would say in answer to my lord's question, it says damage to tangible property. Does that mean that you can have damage to intangible property? And I would say, I have not the faintest idea, but thinking that damage is physical, I doubt it very much, unless it somehow manifests, metamorphoses itself into something which is physical, which I'm not sure it does.
So shall we continue this excursion through the policy at 2 o'clock? How long do you expect to be, Mr. Keeley?
As long as your lordships don't become impatient. I don't want to say that I'm knocking on any particular types of door, whether closed, open, or half closed, but your lordships will find that after this little excursus, I will become slightly shorter.
Very good. 2 o'clock.
All right, indeed.